estate of Milton Boyd.
Bob Engelson for Melissa Dicki.
We have a status conference this morning, as well as, I believe, a motion in limine. Looks like this is Mr. Engelson's motion. Why don't you go ahead and argue that, sir?
Yes, Your Honor. Belaboring the court, because we set it out, I thought, succinctly for the court. October 20 of 2020, Mr. Boyd executed a estate plan, including a trust, with the assistance of Attorney James Pagels. And in that trust, he left his house to Melissa Dicki and divided the rest of his property amongst his siblings and heirs, some nephew, niece. He died in the winter of 2022, and this action was brought, I think, the next year by Mr. Blumberg. So, in a nutshell, we assert, Your Honor, that events that occurred in the summer and fall of 2021, 9 months to a year after Mr. Boyd executed his estate plans, should be excluded as irrelevant and prejudicial and confusing to this jury. As you know, the court's got trial set for the 17th and 18th of this month. Most specifically, there's testimony in the record that was obtained from Mr. Pagels during discovery, including a time when he testified during a hearing, that Mr. Boyd knew what he was doing at the time he executed his estate plan. He was in control of his faculty. In fact, he even sent copies of the entire estate plan to Mr. Boyd's relatives because they wanted to be sure everybody knew what was happening. So the damn thing, maybe both, resulted in a adult protective service investigation, which was presented to the court by your predecessor, but didn't go anywhere. Mr. Boyd died. We want to exclude all that testimony as being irrelevant to what he knew and his capabilities at the time of execution. I could elaborate more, but I won't unless the court has questions. Thank you.
All right. Mr. Blumberg, your response?
Sure, Judge. Thank you. First of all, this case isn't just a challenge to a trust based on the lack of competency of the settler of the trust. It's a case, perhaps even more importantly, which is a product of undue influence. In Michigan, there is a presumption of undue influence where the perpetrator had an opportunity to influence the vulnerable victim. The perpetrator benefited from the action, and the perpetrator had a relationship with the victim. All of those things exist here. So we believe initially, starting from the get-go, there is a presumption of undue influence in this case. Melissa Dicki was a cleaning lady who had provided services to Mr. Boyd and his wife. And upon the passing of Marilyn Boyd, she befriended herself and became very involved in Mr. Boyd's life. To the extent he was already an elderly, vulnerable adult, she knew that, and she's taken advantage of that and manipulated the situation so that she could benefit from his estate plan. As to the competency issue, both Marilyn Boyd and Milton Boyd received assistance from Adult Protective Services long before Marilyn's passing. There were signs of early onset dementia in Milton back then. It was best evidenced by the scam that he became a victim to. And ultimately, Adult Protective Services felt that he was, in fact, a vulnerable adult that couldn't care for his own financial situation. So the very evidence that the respondent attempts to exclude are the critical components of this case. Melissa Dicki benefited from the relationship. He was a vulnerable adult, and evidence of that needs to be shown. It's relevant, and it's not prejudicial. Again, I don't know if the court's had an opportunity to review the briefs in regard to this motion.
I have.
Okay, well, I appreciate that. There is clearly a presumption of undue influence in this case. The evidence that is sought to be excluded is the very evidence that supports the claim that he is a vulnerable elderly adult. No wonder why they want that excluded, because that's part of the presumption that is created by the facts of this case. We think a jury should be able to hear this evidence. They alone will determine the relevance of that evidence. There's nothing prejudicial. There's nothing distorted about the evidence. It is the facts. And there would have been a conservator. In fact, there was a temporary conservator and guardian appointed for Mr. Boyd prior to his death. He was an elderly man who was grieving the loss of his wife, and Melissa Dicki took advantage of that situation. We wanted the opportunity to simply present the facts to the court, and to the jury. We would ask the court respectfully to decline to exclude this evidence and deny the motion.
All right. Thank you both very much. I thought you did a nice job on your briefs setting out the issues. Mr. Blumberg, I do have a question for you. You made mention in your second argument about competency, that there was APS involvement not only in the fall of 21, but prior, excuse me, prior to that time. I didn't see that information previously. Is there some documentation of that someplace?
Oh, there is. We didn't provide it to the court because, candidly, I wasn't fully aware of the extent of APS's involvement. Penny Kelly was involved then as well. She wasn't questioned exclusively about the prior services provided to Milton and his wife, but she will at trial be able to present that to the jury.
All right. So my question is, I'm sure, certainly. Go ahead, Mr.
Well, I was
Engelson,
just going to say, if there's evidence that he wants to bring in before the trial, let's have it beforehand and see whether it actually has any bearing on the issues in this case, rather than show up with trial and let her testify. That's an end run. I don't have any such evidence. We've been at this thing for a couple of years. Where's the evidence? Let's see it.
Mr. Engelson had the opportunity to cross-examine Penny Kelly. He just chose not to ask her.
All right. My question was brought about by this. The cases that I've read, including In re Springer, which was cited in, I believe, both parties' briefs, talk about the time period around, and the statute is very clear that the time period that I'm supposed to be making my decision on is as of the trust agreement being made. And there is some time frame discretion that I have before and after looking at that if it has an impact on the time frame of the trust being made. And so In re Springer said its particular facts was 18 months, and that's not a bright line rule. I understand that. Was 18 months was too long to look at in that particular case. So I was looking for some thread that brought the information that was in fall or summer of 21 back to the time of October of 20 when the trust was made. And if APS was involved to some extent throughout that time period, I think it has a better tendency to bring it back to that time period when the trust was made. So based on Mr. Blumberg's indication, I'd be inclined to allow all of the evidence. My second reason for doing so is I believe that the undue influence issue also would be shown or could be shown as probative by information that was done throughout the time period involved. Undue influence is an ongoing, in my mind, could be an ongoing thing. And I think it's going to be up to the jury to decide how much weight they're going to give that. So I'm going to allow the evidence. All the cases that I read, I also went through Michigan Probate Source Book and looked at mental capacity, both as a trust and as a will. And those two things are substantially similar under 700.
A cleaning lady turned caregiver now stands accused of manipulation.
7601 and 700.2501. I looked at a number of the cases that were done with that, including In re JLD Living Trust from the Court of Appeals in 23, In re Estate of Baird from the Court of Appeals in 20, and Hellebuck versus Tilley from the Court of Appeals in 13, all indicating that there is some time frame surrounding that that is somewhat malleable given the facts of each particular case. And it appears to me that the issue of undue influence and the tie between the APS before the fall of 21 and during the fall of 21 would be sufficiently close in time to allow that to be sent to the jury for determination of ultimate fact. So I'm going to deny the motion in limine and allow that to be admissible in court on the trial date. Mr. Blumberg, would you prepare that part of the order?
I sure will. Thank you.
I don't know if it matters to you or not, but I'm getting messages. You can see the camera.
explain that to me.
One of the other parties of this case has a problem with Miss Dickie's friend recording the proceeding. I just want to let you know.
Okay. All right, counsel, we have a jury trial scheduled for the 17th and 18th, which is in Wednesday, 3 Wednesdays from now, but really a little over 2 weeks. I have received, got it. Jury instructions and a verdict form from Mr. Ingleson. Mr. Blumberg, I have not received such from you.
It will be filed today or at the latest tomorrow, Judge. 2 weeks, I think,
All right.
was the scheduling order.
I believe you're correct on that, so thank you. My concern is there's a very specific verdict form filed by Mr. Ingleson, and then the proposed jury instructions. I know you gentlemen have not had a trial in front of me, but I'm not going to sit and take 2 different instructions and try to integrate them. And I'm also not going to, because I believe we are required to give instructions to the jury. I'm not going to have my staff white out or edit these. So Mr. Ingleson, I appreciate that you've copied for me the civil jury instructions. But you're going to have to submit, along with Mr. Blumberg, 1 copy that both of you approve that I can simply read to the jury and then hand to the jury. So I'm not going to take out the use notes and the comments and the history and the parts of the proposed instructions that don't apply in this particular case. So that both of you are going to be required to work with each other to get 1 copy that both of you either agree on, or if you can't agree on it, very specific typed version from each of you that says, all right, here on this one particular issue, here's what we both disagree on, but everything else needs to be in a form that I can simply read and submit to the jury at that time. So I need both of you to get together on the proposed verdict form. Mr. Ingleson has submitted one with 4 questions as to testamentary capacity, and looks like 5 questions as to testamentary capacity. And then Mr. Ingleson, your numbering under undue influence goes 1, 2, 3, and then 6. So we need to clean that up as well.
Understood.
So if both of you could work on that, I'd appreciate it. Are there any other, I did not see a list of witnesses and exhibits. Maybe I just missed it in my review, but I'm going to need to see that as well. Is there anything else that needs to be decided today?
No, Judge, I think when Mr. Ingleson gets back in town, the 2 of us can sit down and try to work through the jury instruction issues.
I appreciate that. So I'll leave that in your capable hands. If anything changes between now and then, please let us know. Otherwise, we'll be prepared for a jury trial starting on the 17th. I want to see counsel in chambers at 8:30 for the jury trial start at 9.
Judge, is that going to be in the district courtroom where you are right now?
Correct.
Okay. Thank you.
All right. Anything else for today, gentlemen?
I don't think so.
One quick question.
Yes.
As to witnesses and as to exhibits, my normal experience in trial practices, we identify the witnesses between ourselves, and the exhibits we propose. If we agree to all of them, we stipulate if there's any disagreements, then we let the court know that. And we can do that in advance by at least a week, I would think, maybe more.
That's acceptable as far as I'm concerned. Mr. Blumberg, any issue with that?
No, Judge, I think we can work that out.
All right. That sounds good. Thank you, gentlemen.
Thank you, Your Honor. Somewhat of a unique situation. The late Mr. Morgan had retained my office to pursue asbestos litigation based on his lung cancer diagnosis. That lawsuit is still pending, has not been resolved. And when I tried to track down family members, I did reach out and was able to speak with the heir of the estate, which is Mr. Morgan's daughter, Jacqueline Morgan. They apparently are estranged from one another, have been for at least a few decades, and she really doesn't want any involvement in this matter, which I totally understand and respect. And ultimately, because this would turn into a wrongful death lawsuit, the lion's share, if not all of the proceeds, would go to those wrongful death heirs that did have a relationship with the decedent, which would be his siblings. So I reached out to one of his, and I believe Mr. Morgan has several siblings, but Leonard Morgan is kind of the point person for the family. And I spoke with him to see if he would like to serve as the personal representative for the estate, which he agreed to. And again, he's here on the Zoom. I can question him on the record, but ultimately, the only asset of this estate is this pending lawsuit. The decedent did not own any real estate. He did have a long-term partner. They weren't married. And she, based on my conversations with Leonard, she was on the bank account with the decedent. And I think there's a modest amount of funds in there, but it was a jointly held account. But in terms of assets, that's really all that there is.
All right. Mr. Morgan, you have heard what the attorney has said. Do you have any disagreement with anything that he has said?
No, Your Honor, I don't.
And you are asking to be appointed the personal representative of this estate?
Yes.
All right. Counsel, I note on the proposed form that I have, my staff has filled out for me, there is a spot for whether or not supervised administration is necessary. Do you believe that that would be appropriate or not?
I don't believe it's necessary, Your Honor. Once the case settles, I still have to file a motion to approve the settlement and distribution in the circuit court. A copy of that's going to be supplied to all of the wrongful death heirs, including Jacqueline and all the brothers and sisters of the decedent. So I think that covers that part of it.
All right. And I believe you indicated to me previously that Jacqueline, as the child, is not interested in being personal representative. Is that correct?
That is correct, Your Honor.
And Mr. Morgan, is that your understanding as well?
Yes, Your Honor.
All right. Mr. Morgan, is there anything else that you want me to be aware of before I decide what to do in this case?
No, sir.
All right, counsel, is there anything else that you want to say before I sign documents?
No, Your Honor.
All right. It does appear to me that this is an appropriate request for petition for personal representative. It does appear that Mr. Morgan would be an appropriate personal representative. The decedent was a resident of our county at the time of his death, died intestate. Mr. Morgan is a suitable for appointment. Supervised administration is not necessary, so the petition will be granted. I will find that the decedent died intestate. Mr. Morgan, Leonard Morgan, will be appointed the personal representative without bond, and the heirs are noted to be Jacqueline Morgan, the child. And with that, I will sign the proposed order of formal proceedings.
Thank you, Your Honor.
All right, we'll get copies of these out.
They argue the jury should only see what favors their narrow version of events.
And we're seeking the court to approve that settlement for the minor. As such, the minor will be receiving funds, so we're asking the court to appoint his mother as the conservator to manage those funds for that 1 year period before he turns 18.
Is Mom with us today?
Yes, she is, Your Honor.
All right. Mom, is there anything that the attorney has said that you disagree with?
Not at all.
All right. And how is your son doing?
He's doing great now.
Good. Glad to hear that. Sorry for the difficulties that he and you went through that caused by all this.
Thank you.
As to the dollars that are going to be involved in this case, you understand that the dollars that would go, that would flow to your son and those that have been attorney's fees and all of that. Do you have any issues or questions about that?
No, I do not.
And you believe this is in the best interest of your son to do this?
I do.
All right. Is there anybody else that would be a better conservator in your mind?
No.
All right, counsel, is there anything else that you want to bring to my attention?
Not at this time, Your Honor.
All right, I do find that there's clear and convincing evidence that the minor is in need of a conservator because of his status as a minor, that he is owed money or property that requires management or protection that cannot be otherwise provided, and that the value of the cash or property is readily convertible into cash and the estate exceeds the limit for administrating the estate. I will not require a bond. The estate contains no property readily convertible to cash. Cash is already in a restricted account. And I will grant the request for a conservator, appoint Sheena Wilkes, whose address is in Pueblo Trail in Gaylord, as a conservator of all the assets of the individual. and I will approve the amount of $164,220.43 to be deposited in a restricted account. The other amount to be payable to the attorneys who garnered the settlement. So I will approve conservator in that manner. We'll send out a letter of conservatorship to the mother. Ma'am, you'll be receiving some documentation from the court. One of those documents is going to be an acceptance of the appointment. If you could, actually, I do see that you already signed that. I don't see a date on it. Do you mind if I put today's date on that for you, ma'am?
Oh, no, that's fine.
All right, thank you very much. All right, counsel, is there anything else that we need to do today?
Your Honor, I will be submitting a separate order for the approval of the settlement itself. The only reason why I have not done so is I was waiting for the guardian ad litem to submit an invoice to me so I can include that.
All right, that sounds appropriate. I'll be happy to sign that once you send that in to us. All right, that's all for today then, folks. Thank you very much.
Your Honor, I apologize. Can I ask one question? Is there an email
Certainly.
address where I could send that order in?
I'll let my staff tell you what hers is. That would be appropriate to send it to her.
Thank you, Your Honor.
It's C as in cat, Parker, Parker, at Otsego County, MI.gov.
Thank you.
Thank you, counsel.
Thank you, Your Honor. Have a great day.
You too. All right, the next matter on the docket is in Ray James Spillin, file 25-10753-CA. Okay, counsel, place their appearances on the record, please.
Yes, Your Honor. Stephen Balkema on behalf of Stephen Spillin, the petitioner and conservator in this case.
All right, excuse me. This looks like a petition to allow the final accounting and a petition to terminate the conservatorship. Counsel, you want to tell me what it is you're asking for?
Yes, Your Honor. So we're here on a petition to terminate and a petition to allow the final accounting as James deceased on June 15th, 2025. There were only two assets that were part of the conservatorship, a capital funds account that was beneficiary to James's two sons, Stephen and John, and then a Fifth Third bank account that was beneficiary to James's trust. As such, there are no assets that would be part of a probate estate either, Your Honor.
All right. Thank you. Are there any heirs with us today? I do see a Stephen Spillin.
Yes, Your Honor,
is there anything else?
that's me.
All right. Is there anybody else that you know that would be an heir to this estate?
Yes, my brother, John Spillin.
All right. Is there any information that Mr. Balkema has given me that you dispute or that you disagree with?
No.
All right. And are you also joining in this request that Mr. Balkema, the attorney, has made?
Yes.
All right. So, counsel, I understand that there's no other dollars in James' name. They're all in the trust?
Correct, Your Honor. The Fifth Third bank account transferred to the trust via beneficiary designation, and then the capital funds account transferred to James's two sons, Stephen and John, via beneficiary designation.
All right. And the trustee is already in place. There's no issues with the trust itself?
That's correct, Your Honor.
All right. And then you're asking that the conservatorship be terminated. Is that correct?
That's correct, Your Honor.
All right. And this would be the third and final accounting?
Yes, Your Honor.
All right. All right. As to the account, I do find that a petition requesting the allowance of a third and final accounting has been made. That the third and final account appears to be correct and ought to be allowed. Fees and costs appear to be reasonable and ought to be allowed. And so I would so order, and the fiduciary would be discharged and the file closed. As to the conservator, I find that notice was properly given. Petition to terminate the conservatorship, which should be granted. The individual is no longer in need of conservator because the dollars is passed and the dollars have now been settled by way of trust and disbursement. Petition is granted and conservatorship is ended. All right, counsel, is there anything else that we need to do today?
No, Your Honor. Thank you.
All right, thank you all very much. That's all.
Thank you, Your Honor.
Welcome. All right, the next matter is in regard to Carol Buxton. It's file 25-11188-DE. Who do we have at present for that hearing, please?
Good morning, Judge. My name is Howard Collins. I'm attorney appearing on behalf of Edward Jones Trust Company. Elizabeth LaFlame, trust officer, is here with us. I believe Mr. Moore is also here as a witness in case we need his testimony.
Morning, Elizabeth LaFlame with Edward Jones Trust Company.
Thank you very much. All right, I have listed as heirs Julie Tolan, Ted DeGroot, and Corbin Kelly. Do we have any of those persons with us today?
Those are, Judge, I believe those are the people listed as personal representative nominees and a codicil. Those are not the heirs. The sole heir is Jean Hemstreet.
All right, thank you for that correction.
And I don't believe that she's online with us. And I've received no communication from her.
All right, as I understand it, the original will could not be found, but there was a copy of it. Is that correct?
That's correct. And the copy, so the copy was attached. It was an unsigned copy. Mr. Moore had a signed copy that was sent to Edward Jones Trust Company, but lost in the mail.
All right. And Ms. LaFlemme, from Edward Jones' perspective, is there any problem with you, your entity, dealing with this unsigned will as long as the court enters it as part of the formal proceedings?
But that's acceptable, Your Honor. Yes.
All right. So I assume that was true, but I want to make sure. All right. It does appear that I'm sorry. Is there anything else that you want me to be aware of, counsel?
No, I believe the court has the renunciations of the three nominees as well.
Yes.
Yeah, we're just seeking the opening of probate, admission of the will on the codicil, appointment of Edward Jones Trust Company as a personal representative.
All right. Yes, I do see those, and I have reviewed that. And I do have a copy of the original codicil attached as well, so I have reviewed that as well. It does appear that a proper notice was given that the decedent died in November of 2024 as a resident of this county. I do find that the heirs are determined to be Jeannie Hemstreet, his aunt. There was a valid unrevoked will dated December 9th of 2015 with a codicil dated January 4th of 2019. Edward Jones Trust Company would be a suitable appointment. And the decedent's will directs unsupervised administration, so the court will order that the petition is granted. Decedent died intestate. The will and codicil are valid and submitted to probate. Edward Jones Trust Company is appointed the personal representative without bond, and the decedent's heirs are determined as noted above, Jeannie Hemstreet being the aunt, and I will sign that order today.
Thank you, Judge.
All right, we'll get that out to you, counsel, and you can forward on to the appropriate persons thereafter. Thank you.
Thank you.
Thank you.
You're welcome.
Bye now. Thank you for showing up, Mr. Moore.
You're welcome. I'm glad it's working.
They lay out Boyd's vulnerability and how Melissa allegedly preyed on him.
Your pleasure is.
Well, let me do that, talk to the other parties for just a second, and then I'll have you tell me what it is that we should be doing today. If I could have, is it Stella?
Yes, Your Honor. My name is Stella Knight, and I'm an attorney in North Carolina. We're coming to you live from Hertford, North Carolina. And I am here with Miss Judy Stone and her husband, Daniel Stone.
Good morning.
Yes.
Good to see both of you. All right, Ms. Stone, you've heard what Mr. Westerman has said. Could you give me a little bit of information as to the background in North Carolina?
Tell them about the guardianship.
Okay, I am the guardian of my husband, Daniel, and we are trying to sell our home in Gaylord, but North Carolina requires that we get permission to sell because I'm his guardian and we are no longer in Michigan.
All right. So you've moved full-time to North Carolina, as I
Yes, we
understand it.
have.
Correct?
Yes,
All right.
yes,
And how long have you been the guardian for your husband?
about 1 month now.
All right. And is he living with you full-time, or does he require additional care beyond that?
No, he lives with me in our condo in Hertford.
And the sale of the home in Michigan would be because you do not intend to move back to Michigan. Would that be accurate?
Correct, yes.
All right. And you would deposit that in a joint account that would be used for the upkeep of both you and your husband. Would that be also correct?
Yes.
Your Honor, we're planning on having half of the proceeds go into a guardianship solely in the name of Daniel Stone, with Miss Judy Stone as the guardian. And then she would report to the court for half of the proceeds as she spends it for Mr. Stone's care, upkeep, well-being, etc.
All right. That sounds really good in that way. And I assume, counsel, that the guardianship was approved in North Carolina. Is that correct?
Yes, Your Honor, she is bonded also in North Carolina.
All right. And Mrs. Stone, do you believe that this arrangement to be in the best interests of your husband and yourself?
Yes, I do. Very much so.
All right. And do you believe that you are able and capable of maintaining the finances and looking after his best interests, both physically and emotionally and financially now?
Yes, I am.
All right. Is there any other information that you believe will be pertinent for me to have at this point, ma'am?
No, I don't think so.
All right. North Carolina Counsel, is there anything else that you want me to be aware of?
Not at this time, Your Honor.
All right. Mr. Westerman, is there anything else that you want to bring to my attention?
Well, yes, Your Honor, just the fact that the SEV is rated at $191,500 and they're selling it well over that. And also Fifth Third Bank, Judy could testify to this, but Fifth Third Bank here in town rated it at $415,000, which is the exact sale price. So we think that the amount is wholly fair. And again, I'd echo Ms. Stone's statement about this being in the best interest of the husband. Since they don't intend to be here, they can't be in two places and they can't own two places at the same time necessarily, given their status. And so this is very important that they be able to sell this home. So we're requesting that the orders appointing her as temporary conservative in Michigan be entered, and to allow her also to sell and dispose of the marital home at 5085 Greenview Drive here in Gaylord. And I think we presented two separate orders in that regard pursuant to the statutes to the court's attention.
All right, thank you. And Mr. Westerman, I believe that you've stated this, but let me just put it in kind of different words. Do you believe that the sale of the home was at an arm's length deal and was proper and appropriate under all the circumstances?
Yes, I do, Your Honor.
All right. All right. It does appear to me that this would be an appropriate action under the statutes of Michigan and also under the circumstances, given that this couple has now moved on from Michigan to North Carolina. I do find that there's clear and convincing evidence that Mr. Stone is in need of a guardianship and has been granted such by the state of North Carolina. It also appears to me that this would be an appropriate arm's length deal and would be in the best interest of both Mr. and Mrs. Stone, given the fact that they now reside in the state of North Carolina and can use these funds for the appropriate purposes of living and finances to take care of themselves in an appropriate manner. So I do find that there was clear and convincing evidence that a conservatorship is needed due to Mr. Stone's mental inabilities. The money is needed for support, care, and welfare of Mr. Stone and Mrs. Stone. And that the petition for conservator is granted. Judith Braun Stone, whose address is in Hertford, North Carolina, is appointed as a special conservator with authority under the statute to dispose of real property. And I will sign that document now. And I will also sign the proposed order approving the sale of dwelling and authorizing conservator to convey real property. It is ordered that Judith Stone, conservator for Daniel Alexander Stone, has the authority to sell and convey the marital home, commonly known as 5085 Greenview Drive in Gaylord. and it is properly described and legally described as Lot 39 Gaylord Country Club, and is hereby directed to make a deed and execute the deed and all necessary closing documents to Dale Schmitz and Faye Schmitz, conveying for a gross sale price of $415,000, which I find to be appropriate. I will sign a letter of conservatorship today. Mr. Westerman, is there anything else that we need to do today?
No, thank you, Your Honor. I believe we have everything. I will, does the court want me to drop off the certified copy of the North Carolina order we have received from counsel in North Carolina? You have an electronic copy of that sealed.
I'm satisfied with that. I've reviewed that, and I'm satisfied that you have that copy. Otherwise, I wouldn't have this, or have the original, or otherwise I wouldn't have this. So I'm satisfied with that. We will send you these orders so that you can then forward them on to North Carolina.
The tension builds as neither attorney seems fully prepared with answers.
All right, looks like we are here on a review hearing. I do see Donna Churches. Ms. Churches, who do you have with you there?
My husband, Gary.
All right, I do see both Gary and Donna Churches are with us. Donna is the guardian ad litem, or is the guardian. Gary, I believe, is the standby guardian. Do we have any of the parents for any of the children with us today?
No, they're in school.
All right, and Lacey is deceased, is that correct? The mother?
Yeah. Yes.
All right. And the kids, how old are the kids now?
Jace is 11, Liam is 10, Riley is 9, and Mason is almost 3.
Got your hands full.
Yeah.
All right. Tell me a little bit of how they're doing.
Well, Riley, who is 9, he's in foster care. We've had our hands full with him. We're working on that situation. Jace, he's in 6th grade. He is autistic. He's ADHD. He's on meds. He's in counseling. We have a counselor that comes out once a week to the house. He goes in on Tuesdays for counseling. Liam, he's, as he calls himself, the good child. He's doing really well. He's a redhead. Mason, he's 3. He's being raised by his papa. He's 69-year-old. He's, yeah.
Oh, that's good. That's
he's
good.
quite the character.
Yeah.
But he starts Head Start this year. He's, yeah.
All right. So tell me a little bit about the house that you live in and where the kids, where they sleep, what access to toys or stuff, that kind of thing. What's happening at the house?
Well, we were going to try to put an addition on the house, but it just, we got a loan, but it just wasn't feasible for us to do that money wise. I mean, we got the loan, but we discussed it amongst ourselves. So what we did, we went to the building department. We decided to just take the garage.
Put another bathroom in
Put
there.
another bathroom in there for the boys. And it's a huge bedroom for the boys. And
Okay. So they all stay together in a large room? Is that what you're saying to me?
yes.
All right. They have their own bath.
Yes.
As they grow, I mean, are you on any acreage? Is there a place for them to play outside? Are you near a park?
We have 2 acres. Our front yard, they have a great big huge swing set that's got like a playhouse on top of it.
Okay.
We paid what, $600 for this outfit for them. Huge sandbox. Papa built them a great big fort out back.
Great.
They've got trails out back. They take Papa's Ranger out back. It only does like 20 miles an hour, but they drive that out back.
That's always fun as a child. Good. I'm glad to hear that. Medical and dental and eyesight and all that. How are you keeping up on those things?
Very well. Very well.
Okay, any particular issues with any of the boys in those areas?
No, no.
I know that school has just started, so I don't expect, grades and all that kind of thing, but how are the boys doing in school? Is there any
They're A's and
no
B's.
problems?
A's and B's.
Great.
Yes.
That's really good to hear. Social activities, are they involved in any extracurricular activities or any organizations?
Nothing at this time because of all the counseling, and I've got a couple of them that are in bereavement classes, counseling and stuff like that.
Okay.
We've got so much counseling going on right now with all of them.
I think.
Sure. Are any of them expressing any interest in any sports or
Yes.
music or art or anything like that?
Sports.
Always good for boys.
Yes.
Yeah. We're not.
All right. Is there anything else that you want me to be aware of at this time?
We would like to try to adopt all of them. That's what we would like to do. But financially right now, it is pretty tight right now, because I know it is very expensive.
Yep. And there may be adoption subsidies out there. I can't make any guarantees, but if you were to contact the Michigan Department of Health and Human Services, I'm sure that they would be able to give you information as to what programs and what financial assistance is available for families that are looking at adoption. So that would be the place to start for you to begin that process. And they have all of the forms, and they do the investigation, and they can make the help you with getting the process going through the court system. So that would probably be your easiest and best way to forge ahead with that. All right. Is there anything else that you want me to be aware of at this time?
No. The boys all have bikes. They've got hoverboards. They've got you name it. They've got.
Your mom had bought a lot of stuff.
Yeah.
All right. Well, sounds like you guys are taking really good care of them, and I want to say thank you for doing that. I appreciate how hard it is as grandparents to raise the grandkids, but it's time well spent. I mean, I know you know this, but I wanted to say thank you from the court staff, because we see that on a regular basis as well. Even though it's hard, that's time that you can never get back if you don't have it with them now. So they need it, and I know that you want to give it. So we appreciate all you're doing for that. All right, I have orders in for each of the children, but they are similar. So I'm going to find that it is in the welfare of each of the minor children that the guardianship be continued.
How was it where Riley's in foster care? Would his guardianship continue?
I'm going to do that at this point. We'll see if foster care needs to change anything with that. And I believe that the two of you have full guardianship. Is that correct?
Yes.
All right. So we will continue that aspect as well.
Now I have a question.
Go right ahead.
On the bottom of these papers, it says involving an Indian child.
That's a box that would need to be checked if there were any Indian heritage. Are either of you aware of any Indian heritage with the children?
No.
So if there is that, then there are additional procedures that need to be done similar to which would involve notifying the tribe, because there may be benefits and there may be other procedures that the tribe requires. So we're simply, if there is any indication of Indian heritage, obviously the tribe determines whether or not the child is a member of the tribe or not, but they may have access to additional benefits through the tribe that we would be required to talk about. But I wasn't aware of any, but thank you for bringing it up.
Yeah.
So, all right. Let me see if there's anything else that I need to check on these boxes. All right. And I'm going to also sign letters of guardianship, which renew this as a full guardianship. The only restriction on that being that you are not authorized to allow any extraordinary medical procedures such as sterilization, vasectomies, organ transplants, that sort of thing. But you have the full guardianship authority, which means that you are in effect the parents of each of these children. Okay. My staff brought to my attention, and you mentioned it as well, that I believe is it Riley that's in foster care at the moment?
Yes.
There may be some impact on your authority as guardians through the foster care system, or temporarily allowing the foster parents to act as the parent, if you will. But I don't think it changes anything at this moment. You still remain as the guardian of Riley, and if there's any questions about that in the future, we'll resolve that with a future court case. But I'm going to allow you to continue to be the guardians there, so that if foster care is ended, and hopefully that will be the case, and he can return to you, you would still remain as the guardian, and we wouldn't have to do anything special at that point. He could simply be returned to you once his issues have been resolved appropriately. Is there any questions or any other information that you think that would be beneficial for me to have at this point?
No.
All right. I will sign all of those documents as to each of the children, include Mason, Riley, Liam, and Jace. And again, thank you very much for all of your help. We appreciate that. That's all for today then. Thank you very much.
Okay, thank you.
You're welcome.
We're owners again.
Yep.
All right, our next matter is with Donna Sauter, S-A-U-T-E-R, file 25-11191-GA. See, Mr. Mamoser is present with us.
Hi.
Good morning. Good morning. Can I have your name, please?
Down Joe Sauter.
All right. Who do you have with you?
My stepdad, Jeff, and my sister.
All right. Thank you very much for being here today. This is a petition for guardianship. I have received the report of Mr. Mamoser in his recommendation.
Family pleads to take guardianship while the judge weighs the law. It's raw emotion versus legal duty in a battle for care and control. All right, guys, if you enjoyed this breakdown, hit like, subscribe.
And then forgotten first name already. I apologize. Ms. McClucky is here as well. Lana McClucky is here as the sister. And Ms. McClucky has said that the family is considering requesting a different guardian. And so that's when you came on. So let me ask her to repeat that and go into a little bit more detail. And then Ms. Hankins, I'll give you an opportunity to respond as to what you think would be appropriate as well. Ms. McClucky, could you explain your request in a little more detail, please?
Well, I will give it a try. Ultimately, I'm concerned, and as my brother is, for Lori's, her care and her mental health, and having a dear family friend be involved as a public guardian, someone that she has known. Her husband, who passed away in 2026, has known for probably 20 years plus. She really values and counts on the friendship with Jerry Hurst and also Lori Hurst. It's just a matter of deep care and concern to have this be something that is done by someone who has a real history with Lori, knows her deeply, cares for her deeply, as a family friend, and as our family does as well.
And what do you think would be the advantage of changing guardians at this point?
The family friend is very near Lori and could see her as a guardian in terms of doing the legal things involved, but also as a very close personal friend, a very comfort to her, and a comfort to our family.
What history or experience do the Hursts have as being a guardian?
As far as I know, none. But I can't speak any more to that than that.
All right. Is there any other information that you want me to be aware of in regard to this request?
Could you give me more information in terms of what you might be considering or what I'm missing?
No, I'm just trying to be as broad and as general as I can.
Okay.
Just I wanted to make sure that there wasn't anything that I'd forgotten to ask you about. So is there any other information that you want me to be aware of?
I don't think so, you know, other than repeating myself that my sister Lori knows this individual and their family has known them for a very long time. And they're just deep family friends. And I suppose it's a matter of comfort. It's a matter of trust. I think that's probably the best I can offer.
All right, thank you. Ms.
You're
Hankins, could you update me as to your position and how long you've been the guardian and what actions you've taken on behalf of this ward?
Yes, Your Honor. And this comes as a shock to me, actually.
I'm sure.
And I know that this case originated in Emmett County. I was appointed as an emergency guardian, I believe first, and then letters of guardianship issued on May 27th of 25. At that time, Judge Snyder, conducted a hearing. There were no other interested parties. Nobody else wanted to be the guardian. I believe I even had a conversation with Lori Hurst. She is a longtime trusted friend, but she has never indicated to me that she wanted to take on the role of guardian or conservator. And I just only know her that she has certainly, cared for Lori as far as, all along. She was actually one that was going into the home. I believe she, is the one who really brought up a lot of concerns, but she certainly never considered, to my knowledge, becoming the guardian or filing any petition in Emmett County. Then since then, and it's been a long time, I'm trying to look to see when I filed. Once I became guardian, Lori was in, the ward was in the hospital in Petoskey. We were able to place her at Meta Lodge in Traverse City. At that time, it was the closest nursing facility, and she definitely needs skilled nursing care. She has very severe dementia. She did well at Traverse City, and then I moved her to Meta Lodge Gaylord with the hopes that she would be closer to family and friends to visit. And she's certainly doing well there. I participate in care conferences regularly. During the guardianship, I've then discovered that she has assets that I believe exceed what guardianship should be involved in. And even back with Judge Snyder, I knew that, I would likely need to file a conservator petition. Well, then we changed venues. I believe you have the guardianship file. Is that correct, Your Honor?
That is correct, yes.
Okay. So I have never received any petition to modify guardian, terminate for cause, or anything like that. And again, I have been in contact with Ms. McClucky, and felt we had a good communication going. Never heard of anything like this. Ms. McClucky and her son, and I believe her husband, have visited Lori at Meta Lodge Gaylord. Correct me if that's wrong. But I know that they also visited her in Meta Lodge Traverse City. However, the proposed new guardian, to my knowledge, has never visited her, whether in Traverse City or Gaylord. And Gaylord is closer to Miss Hurst in Indian River. Miss Hurst has a business she's very busy with. And again, that bridge was crossed at the point of the original guardianship petition as to who else might become a guardian. And so it came to me as a public guardian, which I've been doing this since 2017.
All right, thank you very much.
I have, did you want to know all the things that I've done?
Just if you could give me a short summary of those kinds of things, of your responsibilities and things you've done in this case.
Yeah, well, obviously, the routine of, taking over the, and this was done before I knew what her assets were, to find her assets, doing the fiduciary taking over of the bank account, and paying bills, finding what her debt was, updating with Social Security, becoming payee rep. I also discovered that the ward had been her deceased husband's personal representative, and the court in Sheboygan administratively had to close that because it wasn't completed. Obviously, by that time, the ward had decompensated so much that she wasn't able to do all of that. So I actually filed to be the personal representative on behalf of the ward in Sheboygan County for the estate of John Sleva, which is still current. I did a house clean out. I have had people come in to tell me what needs to be done at the house. I have an offer on the home, which is another reason I need conservatorship so that I can sell the home. And then once I get all the assets taken care of and get her spent down, I would be applying for Medicaid.
All right, thank you very much. I appreciate all that information.
One more thing, isn't it just before the court today for the petition for conservatorship?
Well, there is, I believe, a guardianship transfer request. And that's so what that's what I have in front of me as well. So there's a guardianship because it came from Emmett County. So we scheduled it for a hearing to determine the appropriate guidelines of what the guardianship could do and whether or not conservatorship was necessary. There's a new part of the statute that gives guardians the authority over financial bank accounts, pensions, Social Security, and other government benefits, and the authority to receive all financial information regarding the ward's assets and to open and close accounts. And I didn't know if there was, because of that, I didn't know if there was a need for an ongoing conservatorship in addition to the guardianship. So I wanted to set both of those for hearing at the same time. Mr. Delaney, having heard all of that as the guardian ad litem, what are your thoughts?
Certainly, family and friends can be better suited to act as guardian or conservator, but not all the time. The court has a court-appointed guardian that appears vested into this case already. I wouldn't have enough information to agree to change, and so the court could take two paths there. One, request or indicate that a motion or a petition to modify the guardianship and change the guardian be filed, or have Ms. Hankins investigate that now and see if she thinks it's appropriate, and then report to the court. But I couldn't agree today without more information. When you have a court-appointed guardian, usually you're in pretty good shape as far as that's concerned. So that's my view on that. And then did the court want to cover the new statute also?
Go what way?
Yeah, I'm anticipating asking whether or not Ms. Hankins believes that would be sufficient instead of the conservatorship. What are your thoughts on that, Mr. Delaney?
Yeah, I think so. And the court probably already knows guardians have sort of historically been exercising some financial control anyway without issues. So perhaps it's a long time coming for the statute to be amended to allow that. Maybe they'll eradicate conservatorships and consolidate it. But I think that relief would be appropriate here.
I have a question, Your Honor.
Certainly.
The amended statute, I know that it used to be, at least in my mind, 15,000. What is it amended to?
There isn't any dollar amount listed in the amended statute. I think they did that on purpose. It was kind of looked at as the guardian could do the minor financial issues, but in reality, the new statute took that away in my mind when I reviewed it. So there is no dollar amount. It's not like the analogy that I would use would be district court and small claims court. The guardian used to be limited to the small claims amount or a smaller dollar amount. I don't see any dollar amount listed in the statute now, so I believe that you would have that available to you, unless you think that there's some other limit that would prevent you, such as the sale of the home, if you think that was going to be a problem under the guardianship. I don't see it now, but then the statute is new and we haven't run through everything as a guardian at this point.
Well, and that makes sense to me. And maybe this is more of a belts and suspenders petition. Because I am selling the home, I did want that authority. But in addition, there is a life insurance policy out there that I need to obtain and, then spend that down too. And they require a conservator, not just the guardianship letters of authority that I've already given them.
All right. My thought is that you're probably going to run into that from other companies based
That's right.
on what the old statute is. So I'm going to ask you to send them a copy of the new statute. If you don't have that citation, it's MCL, Michigan Compiled Laws 700.5314. And what I'll do is I'll keep the conservatorship petition open for the next 60 days to give you an opportunity to send that information out and see if they will comply now with the court's guardianship. Because I will put a citation to that statute and the language that I read into the record just a minute ago, that you do have the authority over the ward's money and tangible property, including but not limited to bank accounts, pensions, Social Security benefits, and other governmental benefits. And you have the right to receive all financial information regarding the ward's assets and to open and close accounts. Would you ask me to put in there as well to deal with real estate? That
Yes,
might be a little more fierce, so I will do that as well.
However, I still know that I will need to subsequently petition the court for permission to sell real estate. Correct?
Yes.
Yes.
That is correct. That has not changed. But so it is unless I hear from you otherwise, it's my intentions to sign an order that grants the transfer from Emmett County to Otsego County to appoint you here in Otsego County as the guardian with those additional financial abilities as the guardian. I will simply keep the conservatorship petition open so that you don't have to refile and incur those costs. But I'll keep it open for the next 60 days to give you an opportunity to try to get the actions done that you need to get done. And if there's any difficulty that you think you need an extension to that time period, please let us know. You can call or contact Ms. Parker at the probate office here in Gaylord, and she'll assist you with keeping that open for as long as it's necessary. But I think that guardianship should now cover what you need it to cover. We just have to give the other people, the insurance companies and the realtors and all that time to understand that there is a new statute that gives you additional powers. So, Ms. McLucky, what I'm going to do with your request is I agree with Mr. Delaney that there's some limited information or some additional information, I should say, that probably should be given to us if you're going to make a formal request to change the guardian at this point. It does appear to me that Ms. Hankins does have a lot of institutional knowledge, has done a lot of good things already as the guardian. It appears that she's right on top of everything at this moment, and I can't see anything different that needs to be done other than what she's done already. Under those circumstances, I don't think it would be appropriate to just bring in somebody that would give a little more comfort to Lori. Nothing wrong with that, and I would hope that the family would continue to do that. But what really needs to be done as a guardian is all of this technical, financial knowledge and action, which Ms. Hankins has appeared to do very well. So if you believe that there is a continuing need for a change, there are forms that can be filled out, and they would ask for additional information as to why you believe the change is necessary and who you believe would be the best or better person to fill that role. So you have the right to do that. That's called a motion to terminate guardianship. And that's a formal document that you could file or any member of the family could file. So I would ask you to do that in the future. But at the moment, it appears that the family is best able to give the comfort and care, which Lori needs, and Ms. Hankins is best able to give the financial judgment and abilities that Lori also needs. And so I would ask that those two things continue to work together at this point. Okay?
Your Honor, I do have a question because I might have missed Ms. McClucky's first explanation. Has Ms. Hurst approached her, or has Ms. Hurst been approached to take guardianship?
I have been approached by Jerry Hurst and my conversation with my brother Rick Knierim to consider a change. This hasn't been a knee-jerk thought. It just is my personal pain of not being able to be a guardian when Lori was in the hospital, and things changed very quickly, and the hospital wanted her out. And a public guardian was, I guess, probably the last resort. My husband and I are cancer patients. We have an adult son who has some issues. And it was just a whirlwind of things, but I will certainly take into consideration, your expertise and think on this and go through the other channels if in fact we wish to continue this.
All
All
right,
right,
thank you.
and you certainly have the right to do that, and there are forms that you can fill out to make that formally done. And I think it would be best if you decide to do that, to do it in a formal manner so that everybody gets notice of it and can think that through on all aspects of that, rather than to just have a presentation like today. Nothing wrong with your presentation today, but it just kind of caught everybody off guard a little bit. We want to make sure that we make the best decision possible. So for now, I think the best thing possible is for the family to help Lori as much as they can in giving her comfort and care, and for Ms. Hankins to continue as the guardian in this case, doing the behind the scenes financial work for us. And until we get a more formalized request, we'll leave things as they are right now.
This is legal and very detailed, and I understand that and appreciate it.
All right. Thank you very much, ma'am. I appreciate that as well. All right. I will sign the order regarding the appointment of a guardian, continuing the appointment of Ms. Hankins with the additional information of the new statute for additional financial abilities. I'll also sign a letter of guardianship so Ms. Hankins has that and can give that to whoever she needs. And I will also sign the order allowing change of venue from Emmett County to Otsego County and continuing the case here. And then finally, I will keep the conservatorship petition open for the next 60 days. And so that Ms. Hankins has that ability if she needs it in the future, she can certainly contact Ms. Parker from our probate division at that. All right. That's all for today then. Thank you very much.
Thank you, Your Honor.
Not the brother, just for the record of parties who appeared. Was that Rick, Lori's brother?
Rick
that was
Neeram?
Lana?
Yeah.
Okay.
Yes.
Okay.
Yes. Thank you. All right. That's all.